Today I have with me our senior attorney, Lance Dutton.
Hey, how y'all doing?
We're so excited about the topic today. We have two experts in the field. We're going to be talking specifically about high asset divorces. Lance, would you like to introduce our experts?
Sure. We have two experts from IAG, two experts I've actually done cases with, so I'm familiar with both of them, but I'm going to let them give a little more background on themselves. But we have Marty with IAG and Luke Thomas. Marty, I'll let you go first if you want to introduce yourself and state all the qualifications and why you are an expert in this field.
As Lance said, my name is Marty Varon. I'm a CPA for over 40 years. I practice at IAG Forensics. During the night, I teach business valuations and some accounting courses at Kennesaw State. I'm licensed and certified to do valuations, and our firm is located in Marietta, but we stretch out throughout the Southeast, and we do family law and also litigation support.
Thanks, Marty. And Luke, go ahead and give you a little bit of qualifications and your background as well, if you could.
Sure. My name is Luke Thomas. I have been with IAG Forensics and Valuation for a little over 8 years now. Started at the firm doing a little bit of, as Marty said, we do family law work as well as other litigation support, so business cases, and but I focused on family law for probably the last 7 years specifically. I'm a CDFA, a Certified Divorce Financial Analyst, as well as a Certified Valuation Analyst at CVA. So,
well, thanks for being here, guys. We really appreciate it. And we're going to kind of jump into this, and we have several topics we're going to discuss. And I'm going to pass over to Jenny here, and we'll start the PowerPoint.
All right, let me see if I can get this PowerPoint shared. Can you see that okay?
yes.
Yes.
Great. The purpose of this webinar today is we really want to give people a general understanding of assets that are common in a high net worth divorce case. And then we're going to give a general overview of business evaluations and what that looks like in the divorce, throughout the divorce process.
So there are a number of assets that are considered separate property, which, as the attorneys would tell us, that those typically can be removed off the table for purposes of negotiation. If at any point in time you received an inheritance from a family member, typically from a family member, this would be considered separate property. You don't have to share it with your spouse in a divorce. Also, if you receive a gift, regardless of when you receive that, this also could be off the table for purposes of negotiation. One issue to consider, if you have kept this in a separate account, it's a lot cleaner. If you have commingled it into a joint account, the other party is going to make the argument that you had then made a gift to your spouse, and you can get into an argument regarding the source of the funds. If you can establish the source of the funds were clearly from an inheritance or gift, then it's possible you could sustain a separate property argument. If it's put into a joint account, it gets a little bit in a gray area. One of the things we always want to look at is the value of the assets owned at the date of marriage. There are passive gains that are appropriate. So for example, if you own Coca-Cola stock at the date of the marriage and you keep it in a separate account and it grows, well, you have not had any efforts in the growth of Coca-Cola stock. So that would be known as passive gains. And those passive gains would maintain their separate property status for purposes of negotiations.
A question I have about that, and something that I think we see a lot, is, you know, someone says, well, this was a gift to me from a particular person, whether it was before the marriage or during the marriage. And then you have some issues in agreeing whether that was a gift to the, you know, the individual spouse or to the party as a whole. And so do you have any recommendations on what people could do to alleviate that issue before it's presented in a divorce case?
So possibly, let's say the gift was from, let's say you're representing the wife, and the wife says, that was a gift from my mom that was intended for me, not to the marriage. Possibly you might want to get an affidavit from the mom. Hopefully she's credible, or even have her come testify in the case or at a deposition that the gift was intended for the daughter and not for the marriage. But that could get to a factual question.
Marty, how difficult is it when you have inheritance, for example, which again, the default rule is it's going to be separate property, but the person gets it and puts it into a joint account. And then we have a relatively long marriage. And I know attorneys have probably posed this question to you, where you're getting bank accounts and you're seeing money in and money out of that joint account. How difficult can it be to actually track the source of funds of that money? Is that something that y'all do at IAG?
And we'll have another slide on this. This is one of the biggest areas that we work in, other than business valuations. We would actually do a tracing, and we'll talk about some of the tracing methodologies in a couple of slides. But yes, so this is typical. And if you could trace the source of the funds, you have an argument, and hopefully the judge will buy it, that you've maintained its separate status, as opposed to the other side's going to come in and argue you just made a gift to the spouse, you left it in there for a longer period of time, and the longer the period of time, it hurts the wife's argument in that instance. If you just parked it temporarily for a couple of days, that helps your argument. So it's really based upon the facts as presented.
And I think you made a really good point earlier about making an effort to put those separate assets and maintaining them in a separate account, because just like Lance is saying, the second that those are, put into an account with joint names, then you have the argument on both sides that the parties are going to make that it's marital, which is going to, at the end of the day, cost a lot of time and money to pull that apart and figure out what is equitable.
Exactly.
I'll say sometimes it's important to do the tracing, even if inherited funds or gifted funds have been put into a joint account. And if those funds were used to pay for marital expenses throughout the marriage, sometimes it's important to even do the tracing so that you can show that someone came into the marriage with a large inheritance and used those funds for the benefit of the marriage. And that way, when we get to equitable division, the judge may give your party some sort of credit for that. Again, Georgia's an equitable division state, so it's going to be up to the judge or to the jury. But it really depends on the specifics of the case, and that's something we can help evaluate when we sit down to look at all the details.
Okay. The next slide we're looking at, Marty, something that we always, I think, struggle with trying to value ourselves is we'll have real estate. I'm going to do real estate first. I know it's second on the slide, but you'll have a real estate that is purchased by one of the parties prior to the marriage. So you have a purchase price, let's say in 2000. The parties get married in 2005, and trying to put a value on the real estate in 2005 can be a little difficult. Can you explain kind of how y'all would look at that and place a value on the real estate at the time of the marriage?
Yeah,
you take this one.
I'll talk about this a little bit. So with real estate, we're looking at the Thomas case, Thomas v. Thomas, and we'll do frequently what's known as a Thomas calculation, where we're going to trace what the value of the property was at the date of marriage and then allocate the appreciation in the property typically to marital efforts if the parties, if the mortgage payments were made during the marriage from a joint account, that had deposits from paychecks and that sort of thing. Specifically, when you're talking about the value at the date of marriage of the real estate, depending on how far back it is, there are real estate appraisers that can do a real estate appraisal to currently of the value at, several years back, depending on how much data there is during that time period. So if you're talking about something from the 80s and 90s, they're probably not going to be able to have that data in their databases to look for. But if you're talking about 10 or maybe even 15 years ago, that's possible. We also can do a couple different calculations. There's a court case, and I can't remember the case off the top of my head, that says you have to come up with some methodology for valuing that property, whether it's a straight line appreciation, meaning here's the value that we purchased the property at, and here's the value today. And we're going to say that the appreciation went up every year, you know, from 200,000 to 400,000. So that's 200,000 in appreciation, and it went up by the same amount. Now, we all know real estate doesn't appreciate that way. Certainly over the last 15 years, there are huge, you know, peaks and valleys to it. Hopefully it's continued to appreciate, but we can also, there are a couple methodologies. Like I said, we can do a straight line appreciation. We can do a rate of appreciation calculation to say, here's what the value was at the date of purchase, and to get to the date of marriage, we can back into that. So we do have a couple different ways to do that.
And Luke or Marty, are you all still able to do that? A lot of times, Jay and I will also see during a lengthy marriage, there is refinancing, and now with the economy, we've seen a lot of that at some point. Can y'all still put a value when there's a refi involved? And if so, kind of maybe just explain how that operates or works in terms of when y'all are looking at putting a value, and you have, especially have a refi, a cash out refi, something like that. If you could explain just briefly.
Sure. Yeah, we can do, and as a part of the Thomas Calc, now you would have a couple of mini calculations within the Thomas Calc when you have a refinance, and in a way that may help us even more, because when you do a refinance, I used to work in the mortgage industry before I got into forensic accounting, and so you know you have to have an appraisal done, and so that would give us an idea of the value at whatever date that appraisal was done. So hopefully it's closer to the date of marriage, but we can absolutely do a we just end up doing a couple little calculations in there and looking at the cash out refinance or a no cash out, either way.
Okay.
Are there any specific tips, this could be for Marty, Luke, or Lance, that you can think of for clients who own real estate and they're getting into a marriage? Obviously, they're not going into that marriage thinking that it's going to fail, but it is a reality in in our world today. And so if you own a home and you're getting married, what can they do? What can a client do to try to protect themselves and their interest in that real estate at that time?
Well, I'd say the first thing is don't jointly title the real estate. We frequently hear about this, and like you said, people don't plan on getting divorced when they get married. So, and somebody will say, if you love me enough, you'll put my name on that. You'll put my name on this. This is going to be our retirement for when we get down the road or whatever. So, title plays an important part in that. Secondly, though, I would say also, if you don't jointly title it, or even if you do, if those mortgage payments for that property, assuming it's got a mortgage or a loan on it, if those payments can come from an account that has separate assets in it and is not jointly titled, stays titled in the party's name solely. That way, it's very clear that the mortgage was getting paid down and it wasn't because of the marital efforts of the party. Once the parties are married, and both of them continue to work in their jobs, and they deposit those paychecks into their checking accounts or their savings accounts, and then pay expenses out of there, whether it's a mortgage for this separate property or whatever, that could create that marital interest in the property. So you want to make sure to try and avoid that as much as possible. And a lot of times we do, especially with high net worth individuals, you see them consulting an attorney before they get married, making sure things are drawn up, even if they don't have a prenup. But that's the best way to do it. Marty, do you have any other?
I would say if you can get a market analysis or even an appraisal, if you can get an inexpensive appraisal at the date of marriage, would not be a bad idea.
And I was going to say off of what Luke said, a lot of times the best way to save yourself or protect yourself would be a prenup. That's a whole separate topic, obviously. But if you have assets coming in particular real estate, and you want to protect it, a prenup is very effective in doing that. Because as you kind of just alluded to, we've already said a few examples, it becomes very easy to commingle or have the marriage contribute, and it can be ever so slight, but the moment you do that, you're going to end up spending a lot of money on having to really dive into what was contributed so you can show a judge. End of the day, we still have to prepare this to show a judge who's only going to have a few hours, if that, to look over the assets. And again, judges don't like math, and they don't like to to have to do a bunch of calculations. So again, it's really important to get things prepped and also presentable in a very easy manner so the judge can see very quickly the number that went in. But again, if you start contributing and commingling, you're going to have to do those type of calculations unless you reach an agreement prior to a trial.
Right. And I'll say, when you mentioned the prenup, you of course want to hire a family law attorney to help draw up a prenup. There are lots of specifics that go into it.
Business contract attorney, you definitely want a family law, as there's about 4 or 5 major cases in Georgia on prenups that are very important. If you don't follow those rules, the courts will find a way to hold them unenforceable. I have a couple right now that we're fighting pretty hard trying to keep them enforceable. So, but they are enforceable in Georgia if you do follow the rules.
And one thing I think that we see a lot with real estate that gets really messy is someone will own a home prior to their marriage. It might be the home they live in for a few years together as a married couple. Then they sell that home and they take that equity, which is a substantial amount from the premarital asset, and they put that into their next home. And tracking that and figuring out what is marital and what is separate ends up costing people a lot of time and money. So the 2 simple things that y'all gave the listeners today, as far as the appraisal at the time of marriage and the prenup, could end up saving them a substantial amount of money in the event that they do have to go through a divorce and trying to figure out that asset.
Right. And they're also, keeping all the paperwork you can and finding that paperwork, of course, is important, because a lot of times there are improvements made to the home, an addition, and then there's always a difference as to what's considered, maintenance on the home versus improvements, finishing a basement, adding on another piece versus improving landscaping or replacing a roof. So, those are all parts of the Thomas calculation that we would do as well, to figure out what is the separate property source of funds versus the marital source.
And because you described that the house was owned by one of the parties prior to the marriage, but then after they got married, if they still live in the home and they're making mortgage payments that are actually reducing the principal, increase in equity, typically those are deemed to be marital contributions towards the buildup of the equity. So already we've got a commingling of separate and marital funds, and that's what the Thomas calculation does.
Yeah, I think you actually made a point that I never really had. I've never seen in my career where someone has a premarital real estate property and then also has a premarital savings account and has the intelligence to pay all mortgages from that property through that premarital savings account. That would be something helpful as well. But again, I don't think I've ever seen a client who's done that before. So that would be a first, but that's a really great suggestion. If someone's coming into the marriage and they have a separate account, they can certainly help keep it separate by only using premarital funds to continue to pay down the mortgage, as you said. Real quick, guys, on the closely held businesses, if you could kind of explain what that is, and then kind of the same concept of how you would value a closely held business.
Okay, so closely held businesses are family-owned businesses, or a few partners at most. Maybe you just want a sole individual, so the husband or the wife, a business that they own. And a business is just like a piece of real estate or a bank account. It's an asset of the marriage, or assuming it has some premarital component, then, or excluding that it has any premarital component. And so just like a piece of real estate, you need to have a value assigned to that business. And that's something that Marty and I do as certified valuation analysts. And there are a number of other credentials that we have. One of our partners is an ABV, an accredited business valuator. But just like with real estate, you have an appraiser. With businesses, you have a valuation expert. And when we look at businesses, we'll talk about how we value them and some of the issues that get into there. But assuming the business is marital, we want to come up with a value for it. And frequently when you have a closely held business, so perhaps the wife has a firm that she owns with one other person, so she has a 50% equity in that firm. The question is, what's it worth? What would somebody be willing to come in and pay her for her share of the business? And there are a number of methodologies and factors that go into how we come up with our value. But it's important to do that because if you ask the wife in that case, she's going to say, well, I am the business, you know, nobody's going to buy this business without me. And of course, the husband in that case is going to say, oh, the business is worth $100 million, you know, so I need my $50 million share. And of course, we're not talking any numbers anywhere near there.
The famous last words on closely held businesses, the client or the opposing party saying, I am the business.
Yes,
Right. And
exactly.
in some cases, that is true to some degree. That's a concept called goodwill or personal goodwill. And we can go down a whole rabbit hole on that, but we can talk about it a little bit later.
Okay. Y'all touched on this earlier on, the tracing methodologies, and I'm going to let Marty or Luke, one of y'all take over on this one and kind of explain each of these if you can, just in brief detail.
Different methodologies in tracing. And so let me give you an example that could really explain it. So let's say at the date of marriage, the wife has $6,000 of assets in an investment account that was clearly earned and generated prior to the marriage. And then during the marriage, she takes from her salary and invests and buys another $4,000 of investments. So now there's $10,000 in the account. 60% of that account is separate property, 40% is marital property because it's generated from marital efforts. Now, let's say the next month, there is growth on those assets. Typically, under the proportionate theory, we would allocate that growth. And let me give you an example. So let's say there was a $500 increase from market forces in the account. We would then take 60% of the $500 or $300 allocated to the separate property account and 40% of the $500 growth or $200 allocated to the marital portion. And typically we would continue this analysis from the date of the marriage all the way until the current date. And we would have a separate column for separate and marital. There are some jurisdictions, however, let's say there was a withdrawal from that account at some point in time during the marriage. There are some jurisdictions that would say you could allocate that that withdrawal as separate, because that would be the first money in was separate property, and that jurisdiction would say that was separate property coming out first. We typically think in Georgia that the prevailing view is that when there's a withdrawal, it should be proportionate. So if you took out $1,000 out of the account, 60% of it should be separate, 40% should be marital. As you put in more money in the marital portion, the percentages continue to change. There is one exception that we've argued before. So let's say there's $1,000 that comes out of the account, and that $1,000 was specifically for a credit card payment that, when you analyze the credit card, had mostly marital, all marital expenses. We would make the argument that $1,000 should be allocated to the marital portion out of the 40% factor, because you could specifically identify the purpose that those funds were being withdrawn.
So Jay and I, we have a case right now dealing with that. And the example, I think it's kind of hitting on a few things you've already mentioned, tracing and also source of funds. And you haven't got to it yet, but I think you have it in the slide later on, the double dipping component we have to be careful of. And so in the case that we have, it was a 401k, and there is a large withdrawal just after the marriage. And so you can kind of make a pretty easy argument there that that was all withdrawn from the separate money, because there hadn't been really any marital monies put into the account at that point yet. But she then takes that money and they use it to buy one of the properties. They have about 7 rental properties that they basically kind of was their side job a little bit. And so you can't have both. And so in our situation, we kind of looked at the marital balance sheet and kind of did some calculations and what benefit our client the most. And obviously our position is she took separate property to then use as a down payment for that residence. And so that residence should all be separate property because it came from a source of funds, separate property. Flip that, And let's say that money was withdrawn a little bit into the marriage, and then you have an argument of, is it marital or is it separate that was withdrawn from the account? And so that's a really good analysis there, because that does come up a lot, and you have to kind of look not only which way you're going to argue it, but you have to see what is more valuable to the client as well, because sometimes if you argue it's marital, it may lose your client money, and there's times when you say separate, especially if a piece of real estate that has gone up in value exponentially, it's going to help the client. So that analysis can be very valuable to a client in terms of not only having a balance sheet, but also having a balance sheet of what's separate and what's marital. So that's really good information there, Marty, and something that we definitely have dealt with. I'm sure a lot of other family law attorneys have also dealt with that too.
And the focus is on both the source and the purpose of the expenditure.
Correct.
Right.
And that's actually a great way to say it. It's the source and the purpose, not just the source all the time. Yep.
Right. And I think this illustrates a good difference between valuation experts or forensic accountants and attorneys. Your attorney is an advocate for your position. And when you work with a forensic accountant, initially we're hired as a consultant by the attorney, and we're consulting with you on your case. But potentially we could be declared as an expert witness and need to testify in a case. And at that point, we're an advocate for our own opinion. We're not an advocate for the party we're working for. We're charged with helping the court determine the factual basis, and so the court can make that decision. So like you said, the source and the purpose really help us pick the tracing methodology that's most applicable to the situation. We don't just pick which one necessarily benefits our client. We've got to look at the evidence that we've got and pick that methodology that's most factual. Now, we may do that as a consultant early on and let you know, hey, you know, this is really a situation of first in, first out versus marital expenses out first. And that helps give you some information that will help you get your case settled, as opposed to running this all the way to trial and finding out at that point that you don't have a great argument for why it should be this methodology versus that methodology.
Luke, I think that's a great point to make, kind of the roles of us as the attorney and advocate in a position that obviously helps our client the best versus you, who is consulting, and you have your reputation and you have to obviously be more of a neutral, but provide not myself, but all attorneys who you work with the facts. So then that attorney can obviously apply those facts to the law and then what benefits. So you are correct. There's a little bit different of a position from what y'all are doing versus obviously what the attorney is doing. And that's why it is important to have both of y'all involved in complicated cases, because attorneys need y'all to help us get those facts and those numbers so we can make the arguments.
And it's been so helpful to educate clients as well on how that everyone is arriving at those numbers, because so often they see, well, I had 6,000, I took it, so I should get that whole 6,000 back. But there's a lot of times so many facts that are convoluted with whatever they've done. And once that you have a financial expert who can really get in and say, hey, you're either shooting yourself in the foot with this argument, or look at these, it makes it more black and white and much easier to understand the best decision for your case and for your finances.
Absolutely.
The settlement prior to trial.
Right.
Right. And we absolutely like to come into a case early on. And we do that we do a consultation with the attorney and with the client to figure out if it's a situation where you need our services. And if you don't, we're going to tell you that, because we're not going to be able to add value to your case, and we want to work with the attorney on the next case. But when we come in early, we're hired as a consultant, and we don't necessarily have to be disclosed to the other side, and we can give you the information and do these calculations and analyses, and that can help get a case settled at mediation. Whereas a lot of times we're getting called a month or 2 months before trial. The parties have already gone to mediation. That was a great opportunity to get the case settled, but they didn't really understand where they were at. And so now you're going to trial and having to pay all those expenses. And if we'd gotten in early, we probably could have helped to, at least educate everybody a little bit on what our opinion would have been.
I think that's a great lead in to just understanding different types of assets in general. And there's a lot of different assets that people have that they contribute to. and a lot of confusion with those different types of assets and what they are, why they're valuable, are they divisible? So we wanted to walk through a few slides and just give people a general overview of a few different type of assets that we frequently see in high asset divorces.
Right. And so a common asset that we see a lot of are equity awards or stock options, stocks as people call them. And there are three basic different categories of equity awards or equity grants that are given. Stock options, restricted stock units, also called RSUs, and then performance units, sometimes called incentive units. Stock options are a little bit older. We don't see stock options being granted anymore or as much or as frequently or even in the last few years. And part of that is because of the tax law changes that have occurred over the last several years. And they're not as tax advantageous for the firms that are companies that are granting those stock options. So you don't see them as much, but you can still have clients that have those stock options. Restricted stock units. So a stock option is when a company, as part of someone's compensation, they are granted, an employee will be granted the option to purchase stock at a set price, not necessarily at the market price. And you're granted, the employee would be granted those stock options, and then those stock options have to vest. And that's a way for the company to keep the employee, retained at the firm. But at some point, typically over a 4-year period, the stock options, and they're usually granted in tranches or groupings, 4 groupings that vest, year 1, 25% of them vest, year 2, the next 25% vest, year 3, the next 25, and then in year 4. And so those are the ability to purchase stock at a certain price. And so there's value there, or potentially value there. The second grouping is restricted stock units. They differ from stock options. Both have stock in the name. The stock option is the option to purchase the stock. The restricted stock units are actual stock units granted to the employee. They're granted, and then again, they vest over time to keep the employee working there, but you're given an actual unit of stock. Now, frequently you will see that there are taxes owed when they're granted and vested. And so you'll sell some of the stock units that you're granted to pay the taxes on the restricted stock units that you received in total. The last one is the performance units or incentive units, management incentive units. We see those a lot nowadays with C-level employees. They're kind of moving away from restricted stock units and a little bit more into these performance units. And we even see these, with below C-level employees as well. Coca-Cola and a lot of the big companies, UPS, will give performance units. And they're, again, stock units that are granted and vested to the employee, and they're based on a number of measures, sometimes for the division or the group and the company as a whole. And so it's sort of a complicated formula to figure out how many units someone may potentially get. So you have to really look at the detail and get that information from the company when you're trying to value those performance units. But a big calculation in this is, or part of it is, vested versus non-vested equity awards. And vested, like we said, granted means that's when you're given the stock option or the equity award, but it's not necessarily vested. The employee's got to stay with the company for whatever period of time to earn, and that's really what the vesting means, is earning that award. So typically, like I said, we see stock options and RSUs and performance units vest over a 4-year period, and it's usually 25% in the first year, 25%, like I said. Sometimes it can be 5 years. Sometimes it can be a 4-year vesting, but 25%, or excuse me, a 3-year vesting where 25% vest immediately at the same date of the grant date. And so that's important because if the parties weren't married until during the vesting period, some portion of the stock options or equity awards could be argued to be premarital. And so you'd have to do a calculation to say how much of that, what's known as a coverture fraction, meaning the percentage of time that was before the marriage that those stock options vested versus the percentage of time during the marriage that those stock options vested. And you mentioned one thing with equity awards is are these able to be divided between the parties, during their divorce. And while a specific company, it's really up to the company in terms of does the documentation, do their policies allow for any of these equity awards to be broken off from the one employee and held for the ex-spouse or the future ex-spouse. And even if the documentation doesn't allow for that from the company's policies, what we frequently have, we advise the attorneys and work with them drafting and languages, having the the equitable portion of the marital units assigned to the ex-spouse, have those held in a constructive trust for their benefit. And there are rules and a lot of language that goes into that. So for instance, if the husband had some equity awards that were granted and part of them vested premaritally and part of them vested during the marriage, and let's say we agreed that the wife would receive 50% of the marital portion, they would still be held in the husband's name because that's what Coca-Cola only allows, but potentially, but we would have drafted in the language that they're held in constructive trust for the wife. And after they vest, she can execute sale of her units and then pay the taxes. The husband would pay the taxes, and there's all kinds of calculations that go into that. But there absolutely can be marital components or premarital components to the equity awards.
And it's important to say that if the spouse is going to receive some in an equitable distribution, that she receives the after-tax amount, because if the owner of the options has to pay the tax on it, he's not getting dollar for dollar.
I think stocks is something that attorneys get tripped up on a lot. It's difficult, and I think, Luke, you really touched on something. It comes down really to two issues on, is it divisible, and also is it marital? Because the example that you gave, if someone has been granted the stocks, say prior to the marriage, but they vested because of 4 years of the work after, then you have the argument of, well, they were granted before, but they vested during. Is that marital? And it really trips people up. It trips the clients up because they see it as just when the money came in. It trips the attorneys up because I think there's a lack of understanding on how the stocks actually are set up and work. And so y'all have been really fundamental in just having and helping us understand the stocks.
I mean, I would definitely agree with that. I think as an attorney, not all attorneys have business background. I mean, fortunately, I know I have a business background a little bit, but you just hit on a few and you can tell. I mean, there's also unrestricted stock units too. You get into that. So there's a lot of different verbiage, and they're not all the same. But some of the issues that you brought up that attorneys have to be very careful with is the tax implications. Again, the vesting, non-vesting is legal arguments because if something has earned prior to the marriage but vests during the marriage, it's our job to argue that the marriage somehow still contributed to that and it should be marital. We're talking about the patent case that held if it's earned prior, it should not be marital unless you can prove that second component of it. So it's interesting because I think there's more disagreement and arguments on stocks in terms of value, but also lawyers, because a lot of times even the lawyer doesn't fully understand what they're arguing against. And there's sometimes we get very frustrated because we have an opposing attorney who just doesn't understand it, and they will not admit they don't understand it. And it makes settlement negotiations very difficult, which is why having an expert sometimes come in as more of a neutral, it almost takes the pressure off. And then now this expert comes in and goes, no, this is actually what this is worth, and this is what's going on. And I know a lot of times y'all can help, again, facilitate settlement and negotiations. And sometimes having an opposing attorney tell you what's going on, people get a little defensive, and it helps having an expert maybe have a little more of a neutral perspective, I guess you could say, on that. So I 100% agree. This is, even for me personally, I think this is the most confusing asset that we deal with in terms of how to even value it, but also how to draft it up, because you can make some serious mistakes in how the language in a settlement agreement or even a proposed final order It's very, very important on this asset.
And the companies set up their own rules. So just like Luke was saying, even if we understand the difference in the type of stocks and what vested and not vested means, that doesn't mean that that company isn't substantially different than a company in another case that you had that the stocks looked exactly the same. So a client might know that, you know, their friend got a divorce and their husband was able to sell their stocks and just give them cash. But in their case, that might not be an option because of the way the company is set up for their stocks.
Well, I think one we did recently, we actually put in there a buyback option where I believe it was the restricted stock units or stock, I can't recall which one it was, but wife got the option. And if wife did not exercise that option, I think we put in there that the husband within 10 days of the option expiring, that he had the ability to go back and take it, saying, if you're not going to exercise it, I will. So there was something else that came up in that scenario. So again, yeah, there's a lot of stuff going on with stock options and the different types of stocks for sure.
Yeah, and I'll mention one last thing on the stock options too. We're talking about stock options in public companies, but you can also have them in private companies. And there's a little bit of a challenge in valuing what's the stock worth of a private company if there haven't been any transactions, but it's still important to ascertain what percentage of those stock options are marital or not marital. You know, the spouse may say, well, they're not worth anything. Well, if they're not worth anything, then give them to my client. But that's why it's important to come up with the percentage and then hold them in constructive trust. And then down the road, they could become worth something and maybe executed, you know, and then at that point. So
that's an attorney's famous last words. Anyone who comes and says it's not worth anything, then we'll take it.
Exactly.
That's the argument of, you know, the assets are worth the same. Okay, well then let's switch assets.
We get that all the time where someone tries to compare apples to apples or apples to oranges, and we're like, it's not worth the same. Yes, it is. Okay, we'll switch. We're not switching. Okay.
Right.
Absolutely.
Exactly.
So here's the next one where I think a lot of people are confused on the differences between an annuity and a pension. So if y'all want to give a brief overview of these two accounts, I think a lot of people will be very educated on this next portion here because a lot of confusion on these two accounts.
I'm going to start showing my age now. 35 years ago, I was a tax officer at a holding company of an insurance company in downtown Atlanta. And as a tax officer, you know, I dealt with the tax issues of the company. But then I would typically get questions from some of the agents that were selling a product called an annuity. And if some of the viewers go on the internet after this webinar and look up annuity, there would be verbiage that's saying why you should never buy an annuity. But that's another story. And I'm not making that statement because I'm not making any investment advice at all. And I'm not an expert in that area. But typically what an annuity is you give a bunch of money to an insurance company. The insurance company then holds it and invests it. However, typically it'll be invested in bank accounts or some kind of item generating interest income, or there's actually something called the variable annuity where they actually invested in mutual funds in the stock market. And at a point in time, typically at retirement age, then the insurance company is making payments, equal payments over the remainder of your life. And the question becomes, how long does that go? Well, it goes for your lifetime. So some people don't like an annuity because they say, God forbid you die pretty quick after your retirement age, you lose all that money that you gave the insurance company. Plus the payments when they're being received, there's going to be two portions. The amount that you invested initially is an after-tax dollars, but the buildup, the interest or the dividends buildup would be taxable. So they would give you actually a 1099 to break out the amount of return of principal versus the amount of income on it. And so some of our agents back then would get complaints, hey, you sold me this annuity, and I showed it to one of my CPA and they said, this was dumb, I want my money back. Well, one of the problems with the annuity is that if you cancel it, there are heavy penalties. And typically the penalties reduce, a common one would be if you cancel it immediately, there's a 7% penalty. If you cancel it after the first year, 6%, 5% in the second year, that percentage goes down. So basically the insurance company, if you don't want to get hit with a penalty, would be locking you in for a 7-year period. So then what the agents at our firm did, once they got a complaint that they shouldn't have bought the annuity, they said, well, the problem that your CPA is saying is that if you die early, you're going to lose all this money. So what would they suggested? That why don't we then sell you an life insurance policy? And so the agent would get a second commission, and then you were hedging your bets, because if they did die early, all of a sudden the life insurance proceeds would be triggered and the beneficiaries would be made whole, typically. So it sounds like a good idea. And we had some good agents back then. So now, typically, if you then go through, you have one of these annuities and you go through a divorce, well, you could probably get the insurance company to agree to pay out 2 checks, if that's how you decide an equitable distribution would be. And hopefully they would pay out the 2 checks, one to the spouse owner and one to the ex-spouse. So there's a possibility, depending on the insurance company, that you could change beneficiaries during the divorce. A pension, and we don't see a typical pension anymore as much now, although some of the companies still do have pensions, some of the larger companies, and a lot of the teachers or the government offices. If you work for a government as a teacher or for the IRS, they probably still do have pensions. And the issue with pensions is, once again, they're going to pay you a set amount for the remainder of your lifetime. Now, there are some companies that accept what we abbreviate as called a quadro, which is a qualified domestic relations order, which you need a family attorney to generate that function and that agreement. And that agreement then tells the company that upon retirement of your employee, you're to write 2 checks, one to the ex-spouse, one to the spouse. They don't necessarily have to be 50-50. They could be based upon how you decide to, what an equitable division would be. But there are some companies, and I think in a lot of the teachers' retirement systems, that don't allow quadros. They just say, we're going to pay this benefit out for the remainder of to our employee for the remainder of their life. And so then would be asked to put a value on the pensions. Well, there are 2 major assumptions that we make in calculating that pension, because we're looking at a payout in the future over a period of time. And we say, how much money would you have to give to this company or put into the bank today in order to support a payout of over this person's expected life? And so that, so let's say he's going to get $1,000 the first month after retirement. The remaining amount in the account then would continue to grow at this assumed interest rate. And then in the second month, we'd pay out another $1,000. The remaining amount continues to grow at this assumed interest rate. And so we would come up with a number that represents, at the end of the person's life, there would be $0 in that account. Well, 2 major assumptions that we're making that we don't know for certainty. One, I can almost guarantee that the interest rate that we assume is going to change over a 20 or 30 year period of time. And I give my students at KSU an example. For example, when my wife and I bought our first home in December of 1980, the interest rate on our mortgage was 13.75%. And the last mortgage we had was more like 3% vicinity. So interest rates are definitely going to change over a long period of time. And the second major assumption that we're making is that that person is going to die exactly at the point in time that the actuarial tables dictate. And we know that that's not true. They're either going to live longer or shorter. If they live longer, we have undervalued the calculation of the pension. If they live a lot shorter, we have overvalued our calculation of the pensions. So It's really good if the company allows this qualified domestic relations order, because then the two attorneys can negotiate an equitable settlement. But if there's no quadro involved, could be a tough asset to value and divide, because it typically, if a lot of it was earned during the marriage, it does have marital components, and the spouse, we call it the outspouse, would be entitled to some kind of a benefit.
Right. And so what we'll frequently do is we'll do a coverture fraction to determine the marital portion of the pension, and then have the attorneys draft language again where it's held in constructive trust. And then at the point when the parties retire, that party would be responsible to cut their portion of the check to their spouse. And, you know, it's not, like Marty said, we'd rather have a quadro rather than wait and depend on the, you know, ex-husband to pay the ex-spouse, but that's sometimes what you have to do with pensions. We don't frequently like to have pensions. It's a retirement vehicle as opposed to an annuity, which is really an investment vehicle. But the pension, we don't like to compare that to a 401k or an IRA, which we'll talk about in just a second, because a pension, as we said, it's difficult to really value. And so we'll put those below the line, split the rest of the retirement assets, put the pension below the line, and figure out, you know, how much one spouse should pay the other for their portion of it.
I know we're running a little bit short of time, but the last question I have real quick is back to the annuity. Is that divisible? Because that's more of an investment tool. And then just real quick, a lot of annuities have surrender values too. To divide the annuity, is the only way to divide it by surrendering the entire asset, or how does that work?
So if you surrender it, you might have a penalty that the company is going to charge you with, so that might not make financial sense to surrender it.
Sure.
If you've owned it for quite a period of time and maybe gone past the penalty period, like typically more than 7 years, that might be a good way of settling up equitably on it. Or you could check with the company to see if they would split two checks, make two checks on payout, because that could help resolve the issue.
Frequently, just we'd like to, you know, if you come up with the surrender value, that's the value of the asset today of this annuity, and you can, you know, then horse trade that for other assets in the marriage in the best way, if possible. All right, I'll go through these next two slides pretty quickly. I know we want to try and get to some questions. So IRAs, you know, and I'll add in here also versus 401k. So you've got a Roth IRA, a traditional IRA, and a 401k. They're all retirement assets, but they're all different. And the big differences between an IRA and a 401k, if you're going to divide that asset, you're going to need a quadro, as Marty mentioned earlier, and you're going to need a family law attorney to draft that quadro. So if you figure out that the 401k is marital and 50% of it should go to the wife and 50% should go to the husband, you have to have a legal document drafted that'll cost a little bit of money to split that up. Whereas with IRAs, whether Roth IRA or traditional, an IRA, typically you can just fill out a form that each of the parties don't even need an attorney, and submit that back to the administrator, and they'll split the asset depending on how you tell them to. You can have it rolled into another IRA, or you can have funds taken out. Now, if you have funds taken out, of course, there are going to be some tax implications, early withdrawal penalties, and then income taxes would be owed. But a Roth IRA, so a traditional IRA, it's sort of like a 401k. You're putting in money into the IRA before taxes, before you pay income taxes. Whereas with a Roth IRA, you're putting money in after you've paid your taxes. And people will say, well, why would you do that? And with an IRA, you put in that pre-tax money, that way you're reducing your taxable income. With a Roth IRA, you're putting it in after tax, but when you withdraw the funds in retirement, a Roth is not going to be taxable. The IRA, you're going to have some taxable gain. You've essentially deferred your taxes until later, right? You took money out before you paid taxes out of your paycheck, and then when you start retiring, you're going to have to pay pay taxes on that money at some point. Again, you're going to put these up in the retirement section of your balance sheet and divide those assets. You know, IRAs, like we said, because you don't need a quadro, it's a nice way to just, you know, use that count to offset the other retirement accounts. They are divisible, and then typically you don't want to change beneficiaries during the divorce. You know, there's usually a standing order issued in almost every county, I think, which says, you know, you go about your normal course of business, but changing beneficiaries is not usually a normal course of business. You do want to make sure to change beneficiaries after the divorce, you know, if the parties decide that's what they want to do. And then we can go, do you have any quick questions or?
I think that's good for that one. I think
Okay.
IRAs are probably the easiest retirement asset to deal with that we can talk about. And I think
Absolutely.
the main point as attorneys, that's one of the assets that we kind of use to play with to get things equal a lot of times. So I would tend to agree with that.
And I think a good point to make is we spent the first part of this webinar talking about separate assets, but that argument and all of those facts bleed over into all of these assets. So frequently we have, you know, these assets are in a marriage, and then you're figuring out what portion of any of these particular assets are separate or marital. So I just wanted to make sure that everyone understood that just because you have a Roth IRA doesn't mean it's marital. That's still subject to that argument we talked about earlier, figuring out what is separate and what is not.
Yep.
Absolutely. All right, we'll talk about business valuation. I'll try to do this in like 2 minutes.
A whole nother on this,
exactly.
but this is a good lead-in to how to evaluate a business. We just wanted a really broad overview, and we can dive into that in a whole.
Absolutely. Marty and I could spend many hours regaling you guys with fabulously interesting details. But so for a business, again, as we talked about a closely held business earlier, what's the value of that business? And we use, Georgia law says 2 things. One, we have to look at the business under the fair market value standard. And what that means is a hypothetical seller and a hypothetical buyer, both willing and both having full knowledge, what would they pay for that business or sell for that business? As opposed to there are other standards that you could look at, fair value. In different states have different rules, but in Georgia, we look at fair market value. And then Georgia law says we have to look at 3 approaches. We have to consider 3 approaches. It doesn't mean that we have to put equal weight on them. It doesn't mean we have to put any weight on one particular approach. We may put all the weight on one approach or split them or whatever. But the 3 approaches are the asset approach, the income approach, and the market approach, AIM. Asset approach is easiest. That's really, you know, what is the value of the company if you sold off their assets, paid off their liabilities, what would you be left with? We typically don't use that approach or put a lot of weight on it, I should say. It's considered, but for operating entities. The only time you'd really use that is if a business is potentially going to be bankrupt or is losing value, or if you're looking at like a real estate company or a manufacturing company, because then you're buying that business for those hard assets. But a lot of service-oriented businesses, dentists and marketing companies, those are ongoing concerns that are looking at, you know, their client list and how much revenue they're generating. So the asset approach, though, is important for service-oriented businesses because it establishes the floor, right? You can't say that your dry cleaning business is worth less than if you sold off the equipment and paid off the debts, right? So that's the lowest value possible for that business. I'm going to skip down to the market approach second. The market approach is sort of like FMLS for homes. If you guys are familiar with real estate transactions, when you hire a realtor or a real estate agent to sell your house, they'll go look up comps in your area in the last few months for what homes similar to yours, hopefully in your neighborhood or nearby, same square footage. We do the same thing with the market approach for businesses, but we're going to look for the same industry. We're going to go back as many as 5 years, but we're really going to put weight on the last 2 or 3 years typically. And we're going to, when you talk square footage for homes, we're going to look at sales for businesses. So if you're looking at a dental practice, hopefully it's sold in the last year or 2 in Georgia, and they both, you know, you're looking, if your subject company has $1 million in revenue, you want to look for companies that are close to that. You don't want to compare a $30 million company to a $1 million company typically. We are limited in the market approach as to what transactions are reported in the databases, right? We don't, almost every home transaction is reported in FMLS. Not every business, certainly not, are reported in the database. So that's a limiting factor there. And lastly, the income approach. This is really the meat and potatoes of a lot of business valuations for service companies. And the bottom line here is, from an investor's perspective, they want to know how much after-tax cash flow am I going to receive on an annual basis? And then you divide that by the risk rate for owning a private company, right? Owning Coca-Cola stock is a lot less risky than owning stock in a small, closely held business. So the risk is higher. So the higher the risk, the more the increase in value that you would require to own that company. So the income approach is really, we start with the tax returns and drill down till we get to after-tax cash flows. That's really the important number. How much money could a particular investor expect to receive on an annual basis? Not what has somebody been receiving as the owner, because there are adjustments that need to be made, but that's sort of the quick and dirty of business valuation.
And again,
And there's a lot of subjectivity in each of the approaches.
Absolutely.
Yeah, and I'm really excited about that webinar because I think that business evaluations are so interesting, and the arguments that people make on why their business should be valued a certain way is really interesting to talk through and to learn, because there's obviously pros and cons of evaluating every type of business under either one of those formulas. So I'm excited to talk to you guys about that. Y'all have been so helpful for us in evaluating businesses and resolving cases when there is a business involved. We're going to ask a few questions to y'all, but I'm going to leave this contact slide up here just so that people have your information and they can get a hold of y'all. One question that I had seen and I have is for the annuities and the pensions. Can you just clarify, is an annuity is private and a pension is always through an employer, or is that not always the case?
The annuity is, yes, all private typically, and a pension would come through some kind of a company. So there would be some kind of an employer establishment or government.
Is there always that initial investment that you had talked about as far as the annuity, where you're putting a lump sum into that account versus a pension you're really earning over time, right, as you work for a particular company?
Or an annuity, you could either do a lump sum or you could do contributions over a period of time to the insurance company. So that's a possibility. And yes, the pension is earning over time from your employment.
And so traditionally, when people do set up an annuity and say they put $100,000 in an annuity in their 40 years old, and they happen to pass away 5 years later, are those typically set up where that $100,000 is then provided to their family, or is that $100,000 just gone?
Usually there should be a provision that you get back at least a return of your principal at a minimum.
Okay.
That should be in the annuity. You don't want to buy an annuity with the risk of losing it immediately.
Right. It seems like a huge gamble that someone would be making.
Really.
We will get a financial advisor one of these days to come in and explain the
Yes, they're tricky. We've got a few cases with annuities right now, and just figuring out what was separate and the value and what they can do with that annuity has been difficult in this case.
Yeah, the one we have is someone who had a 401k prior to the marriage, withdrawals during the marriage of the 401k, and then at some point took all the money in the 401k and then bought an annuity with the monies in the 401k. Wow. So you have a lot of tracing back there. And then also we have a surrender value on it that is far less than what it's worth because she just bought it a couple years ago, and kind of bad timing that you're going through a divorce right after you bought it. But we're definitely done with that, and we've seen them, and again, they're not as common as they used to. Right. When they do come up, they can be very tricky for us, for sure.
And one more question, just to give people an understanding of what it looks like as far as having a neutral in a divorce case. So, say we have a husband and a wife, and a husband owns a business, and the attorneys agree that y'all are going to be hired as a neutral to evaluate that business. How does that work where you're not really advocating for one or the other?
Right. Kind of like I said earlier, we approach the case where we're advocating for our opinion, And certainly as a neutral, it makes it a little more challenging, but we like to meet with both sides in that case. And certainly the business owner, and then what we would call the outspouse or the non-business owner. It's important because the outspouse may still have a lot of important information that's relevant to our business valuation. But like I said, we would do the valuation. Ideally, we're not a mercenary. We're not a hired gun. We're not, depending on who we're working for, if we're hired for the business owner, we're not going to lower our value just to make them happy. And we're not going to increase the value for the outspouse either. So we're going to do the valuation the same, and the numbers should come out the same. Of course, that's dependent on the information we get. And like I said, we'll request a lot of documents from the parties to make sure, tax returns, financial statements, that kind of stuff, keep it targeted. But then we'll also want to sit down and speak with the parties each separately with their respective attorneys. And then potentially we may all get together and then go through the business valuation, or again, go through it separately and have everybody ask questions and kind of do some revisions as we go along.
And I think that's really important what you talked about as far as meeting both people, because even if one spouse isn't involved in the business, they may have very important information that the business owner is not going to just volunteer. Whether it's, an issue with cash payments or assets that might not be on the books, but that are there. So it's really important to have both people involved for full disclosure, but also for comfort of the parties, knowing that they're really getting to a fair resolution.
Absolutely.
Well, the best example is, Marty and Luke, we know we've dealt with a number of cases, but if you're just going with the financials and you have tax returns or QuickBooks, but I think, Luke, it's always one of your favorite sayings, garbage in is garbage out. There are sometimes the other spouse can say, I know those books aren't even close to being accurate.
Exactly.
He has 150 more clients over here that he puts on paper and they're not reported. And so that would change the value of the business. And that's nothing against Marty or Luke, because they wouldn't know about those customers or other revenue sources, but for the other spouse showing that information. And that, I think, really, where as a neutral, that comes into play. But if Marty or Luke is hired only by one attorney and the only source of information is from that one particular spouse, again, their information may be limited, and all of a sudden they get up on the stand and they're getting cross-examined with information that they were never aware of. And that's not a fun day for y'all in court. And it's not a fun day for us either. So I think it's always, in my opinion, I like having neutral evaluators, because the more information that y'all can get, the more likely we can reach a resolution in the case. And that's still ultimately the goal, is to reach a resolution prior to going to trial.
Absolutely.
And sometimes we could decipher that there is some unreported cash. So for example, we have access to industry ratios. So for example, let's say, just for hypothetical, we were doing a landscaping company, and let's say there was allegations of unreported earnings, and our industry ratios might say that the cost associated with installing this amount of revenue, generating this amount of revenue, is 40%. And then we see that their cost of their materials is way below 40%. So then that would be an indication to us there must be additional revenue that's not being reported because your costs are so out of whack.
Yep, that's a great example. And I know as attorneys, we're looking for that too, but obviously y'all can do a much, I think, more thorough job than we can, because most attorneys, again, we are not CPAs. We're not experts in that field, and it helps tremendously to have someone like y'all to go through those documents and dig in much deeper than I think either of us can.
Yeah. So Marty, Luke, thank you so much for your time today. I am going to make sure that this recording is available for people to re-listen, and if you'll keep an eye out on our social media, we'll release the date for our next webinar. We're really going to dive deeper into business evaluation. So thank you so much for your time today.
Thank you
Thank
guys
you for having us.
Thanks, guys.
Bye.
Take care.
Take care.